Hello and welcome to Hello and welcome to the Week 3 podcast for LWS011 Journalism Law. I'm Peter Black. This week we are beginning to look at defamation law, and we will spend a few weeks looking at defamation law, and in particular with two podcasts on the topic. The first podcast, this week's podcast dealing with defamation, sets out the elements of defamation, what is meant by that term. The second podcast that you'll have next week deals with the defences to defamation. And as you'll see, many defamation cases really turn upon the applicable defences that may be relevant in a particular instance or not. But as I said, this week we're going to be focusing on what is meant by defamation itself. And so we'll talk a little bit about where we get defamation law from and what it is meant to achieve. And then we'll go on to have a look at the three elements that make up or constitute defamation. The first thing that we need is that there has to be a defamatory matter. So we'll look at what is meant by that. The second element that we'll look at is that of publication. And then the third element is that the statement, that is the defamatory matter that has been published, must be referable to the plaintiff. And as I said, in next week's podcast, we'll move on then to consider whatever applicable defences may be relevant in a case. So, by way of introduction, as you would no doubt understand and appreciate, defamation poses an inherent difficulty in reporting and journalism. Journalists are in the business of publishing controversial news stories about people and their activities. And so it is inevitable that the spectre of defamation will arise in many instances in the practice of journalism. But the law of defamation aims to protect the balance between the right of the public to know and the personal right of the individual to their reputation. And that is that tricky balancing act that really is at the heart of defamation law. And indeed, if we were to think about that balancing act in the context of the two podcasts that we're going to have this week, on this topic, this first podcast, in terms of what is meant by defamation, really is looking at the personal right of the individual to their reputation. The podcast that we'll have next week, which deals with the defences, that says in some instances it's okay for an individual to be defamed, really touches upon that other balancing factor, namely the right of the public to know. And the way in which that balance is ultimately struck by defamation law is in the interplay between the elements of defamation as well as the applicable defences. The other thing that I think makes defamation quite an inevitable difficulty in reporting and journalism is that the reality is that defamation is almost a daily occurrence in our lives. We all say things from time to time about other people that could potentially be considered defamatory, that could harm an individual's reputation. Of course, the overwhelming majority of those cases, perhaps even 99% of those statements, never end up in a defamation lawsuit before the court. And indeed, probably the main reason for that is the very simple fact that defamation lawsuits are notoriously time-consuming and expensive to bring before the court, which means that for most people it's never really an option to file a defamation lawsuit. Defamation, the sad reality is, does tend to be something that is a tool of the rich and famous, as we will see in the various cases that we consider throughout both this podcast and the podcast next week. So, what is at the heart of defamation law is reputation. So the concept of reputation is essential to defamation. Now, reputation is defined in the Cambridge Dictionary as the opinion that people in general have about someone or something, or how much respect or admiration someone or something receives based on past behaviour or character. So reputation is about the extent to which public perceptions of individuals are supported by a person's character. Now, as you also would no doubt expect, there are intersections between defamation law and privacy protection, and we'll discover this and learn a little bit more about this later on in the semester. But just at a basic level now, what's the main difference? Well, privacy aims to protect the individual in their self-concept through the control of their personal information. In contrast, defamation protects also a range of interests, but this also includes the property value of a person's reputation and protecting the individual's right to be himself or herself and to reach self-realization within society. Or basically, if we want to summarize it a different way, privacy laws protect how a person feels about themselves in relation to themselves only, whereas defamation law is concerned about how individuals feel about themselves with respect to society and how society as a whole perceives that individual. Now, defamation is described as a tort. That means it's a civil wrong, and as such is distinct from criminal law. Now, other examples of torts include things like negligence or trespass or conversion. And what's a feature of these torts or civil wrongs as opposed to the criminal law is that if you have defamed someone, you don't get arrested by the police or prosecuted by the state. It's the individual that has been wronged that takes his or her own legal action. That is, by suing that person in a court for defamation. It's not as though there is a prosecution that is done by the state when we're talking about criminal law. So you need to remember that defamation is a tort law and it's a civil wrong. Now, the historical basis for this stems from the fact that people's reputations were seen as part of their spiritual beings. So, as such, defamation proceedings were initially and often brought in the ecclesiastical courts of the Church of England. However, from the 16th century or so, defamation actions were increasingly brought in the common law courts. Now, in Australia, as we've already seen, we received English law, but defamation was put in legislative form in 1847 New South Wales by the Defamation Act. Now, after the separation of the various different colonies and then states, some chose to repeal the act and to revert to the common law, some adopted it, and others enacted their own legislation. Now, at Federation, the Commonwealth Parliament was not granted the power to deal with matters of defamation law, so defamation law was left up to the various different states. And as a consequence of that, for most of our history, Australia had 8 different defamation laws scattered across the 6 different states and the 2 territories, with a strange combination of legislation and the common law. However, in 2006, we basically saw Australia adopt uniform defamation laws. So it was a historic occasion of cooperation among Australia's states and territories, and so in 2006, we got more or less the same defamation laws to be adopted in the 6 states and the 2 territories. Now, it's worth noting that although we refer to these as uniform defamation laws, there are still some differences in the numbering, as well as in the roles of the judge and jury in the different states and territories. It's also worth noting that the dead cannot sue for defamation in anywhere but Tasmania. But by and large, we more or less have uniform defamation laws now across the country. There's not the same jurisdictional differences between the various different states and territories that we saw prior to 2006. Also prior to 2006, corporations in Australia could utilise defamation laws to protect their reputations from an organisational, product and cultural perspective. However, following the Uniform Defamation Acts of 2006, corporations generally are not able to institute defamation proceedings. There are, however, some exceptions if we're talking about private bodies and not-for-profit organisations, or if they employ fewer than 10 employees, they may still be able to sue for defamation. But again, by and large, following the introduction of these uniform defamation laws in 2006, corporations are not able to sue for defamation. As such, attacks on corporations not fitting the exceptions above must be redressed through other actions. So that's not to say there's not going to be other parts of the law that won't provide remedies for corporations in those instances. There are. It may well be that the companies are able to institute proceedings under various competition law regimes, such as misleading and deceptive conduct or false representations. There is also the tort of injurious falsehood that can also sometimes be used in those instances. Note, however, that corporations can be sued for publishing defamatory material. So while they may not be able to sue for defamation, they can be sued for publishing defamatory material. Within Queensland, the legislation pertaining to the defamation law is the Defamation Act of 2005, which was brought about by the Uniform Defamation Acts. The objects of this act include the following: to ensure the law of defamation does not place unreasonable limits on freedom of expression, publication and discussion on public interest matters and matters of importance, to provide effective and fair remedies to persons harmed, and to promote speedy and non-litigious methods of dispute resolution. Defamation is a tort of strict liability, means that a defendant may be liable even though no injury to reputation was intended. It doesn't matter what the intention of the individual was when they uttered the statements, but if the effect of those statements are such that it does harm a person's reputation, then they can be liable under defamation law, as I said, regardless of the intention. Now, in order for an individual to commence an action for defamation, there must be a publication, as well as that publication must be capable of defaming an identifiable person or persons. That is to say, as I said right at the outset, there are three elements that must be established for an imputation to give rise to a cause of action. The first is that there must be a defamatory matter. Second, there must be publication. And thirdly, it must be referable to the plaintiff. Then, as I've already said, any applicable defences will need to be considered, and we will look at the defences in the podcast next week. What we're going to do this week is to look at these three different elements that need to be established for an imputation to give rise to a cause of action. The first, defamatory matter. Now, in order for a publication to be defamatory, it must convey defamatory imputations. Here, what you need to do is to look at the meaning of the words, noting that an imputation is an act or condition asserted of or attributed to a person. So you're looking for these defamatory imputations, acts or conditions asserted of or attributed to a person. When commencing an action for defamation, a plaintiff must plead imputations that describe the publication's meaning. That is to say, that the plaintiff must identify all of the meanings arising out of the publication. This involves an interpretation of publications on many levels, such as reading between the lines. Also, in deciding whether material is capable of being defamatory, a court will take into account what a publisher intended. A court will not take into account what a publisher intended the words to mean. Instead, they will look at how an ordinary person of average intelligence would interpret the words. And that comes from the case of Hepburn and TC and Channel 9. Now, in deciding whether the material is capable of being defamatory, a court will look at the publication of imputations in three respects. First, the natural and ordinary meaning of the material, or the literal meaning. Secondly, the inferences which arise from the direct meaning of words, being a false innuendo, that is to say, though not specifically stated in the publication, a reader is able to draw conclusions from what is written. And also innuendo, meaning material is defamatory that are known to a person or class of persons. Publishers must be aware of whether or not their words convey the meaning intended. So you need to be very careful when you are writing to ensure that you are aware of the audience which you are writing for. That is, use of technical or slang, for example, use of technical or slang language may have a different imputation for a younger audience than for an older audience. Now, also in terms of the meaning of the words, it is important to consider the overall impression of the material. So, for example, a story about a house being destroyed by fire when its owners were holidaying overseas must be considered together with the remainder of the imputations within that article, such as the fact that the property was subject to a controversial development application, and comments are found in neighbours, with comments from police officers to the extent that all fires are treated as suspicious until a law has disproved and we will follow all lines of inquiry. Now, in those circumstances, the Queensland Court of Appeal reflected that the offending article did not report the fire without comment. Instead, it attempted to link the fire with contentious development proposals, giving rise perhaps to a defamatory imputation. So, a matter will be defamatory then if it has a tendency to expose the person claiming to be defamed to hatred, contempt, or ridicule, lower the person claiming to be defamed in the estimation of a right-thinking member of society, and cause the person claiming to be defamed to be shunned or avoided without any moral discredit on his or her part. So let's just briefly go through those again. So if it's likely to expose the person claiming to be defamed to hatred, contempt, or ridicule, hatred, contempt, or ridicule. If it's likely to, or have a tendency to lower the person in the estimation of a right-thinking member of society, and also to cause the person claiming to be defamed to be shunned or avoided. So that's what is usually meant by something being defamatory. Now, this means that material can be defamatory to a section of the community as they are aware of certain facts which are not common knowledge and may also be unknown to the publisher. So that's really important and worth remembering. So this can also occur with respect to special knowledge of particular trades or professions or in relation to slang and other language. Therefore, journalists must be very aware of the use of technical language and only use non-technical language when they fully understand its meaning. So the standard then to work out what is defamatory or not is that of the hypothetical referee, an ordinary reasonable member of society. So that's what you need to consider when working out whether something is defamatory, whether an ordinary reasonable member of society would consider that it is defamatory. An ordinary reader, listener, viewer has different attention spans for different media. This also means that cartoons, caricatures, jokes, or satire may be defamatory depending upon the context of the publication. There's not always it's not always clear that cartoons, characters, jokes, or satire will not be considered defamatory. So, in terms of then getting a better sense for what has been considered defamatory, I would encourage you to have a look at the textbook, Pearson and Paulden, where they go through some cases. So, for example, there's the steeplechaser case in the United States, in which a gentleman steeplechaser was photographed carrying his saddle in such a way that rather than being attached to the saddle girth appeared to be attached to him, giving rise to what Judge Leonard Hand described as a monstrous and lewd deformity. The photograph appeared in an advertisement for Camel cigarettes, and the unfortunate depiction was entirely unintentional, but still defamatory. There's the Abbott and Costello case from 1999, where author Bob Ellis held that then Liberal Minister Tony Abbott, now Prime Minister Tony Abbott, was held up to ridicule by repeating an unfounded rumour that he had formerly been a member of the right wing of the opposing Labour Party and had abandoned his party in exchange for sexual favours. Again, also defamatory. There was the Burkoff case in England in 1996, where an article in the Sunday Times, which called an actor hideous-looking and repulsive, worse-looking than even Frankenstein's monster, was held to be capable of damaging his reputation by exposing him to ridicule. There was the Boyd case in 1980, where the New South Wales Supreme Court held that it was holding a rugby league footballer up to ridicule for a newspaper to describe him as fat. There's the Moham Wild case of 1997, in which it was held that the plaintiff's reputation was capable of being damaged by ridicule when he was depicted in front of a billboard showing two women's bottoms captioned OI, and a montage of a lingerie model in a bra and panties with a piece of rope between her teeth over which the words "they like to watch" had been superimposed. Then there was also what's described as the bondage case in 2003, a case of mistaken identity in which a solicitor sued Sydney's Sun Herald, which referred to him as practicing a piano-top bondage display for the gay and lesbian Mardi Gras and accepting a brief on bondage. And then there is, of course, the case of Eddinghausen and Australian Consolidated Press. In this case, HQ magazine published a photograph of 3 Australian rugby league footballers in a steamy shower after a football match. One of them was Andrew Eddinghausen, known as E.T. In the photograph, he was standing with his body facing the camera, his head turned and his arms crossed. Between his legs in the grainy, shadowy photograph was a shape the court decided was capable of being interpreted as his penis. Eddinghausen sued, claiming the photograph held him up to ridicule and compromised his position as a fashion model and a junior development officer with the rugby league. There are lots of issues in this case, and I would encourage you to have a look at it. But ultimately, the court considered here that this did indeed constitute defamation. The court looked at the defamatory meaning that came from publication and said several meanings may emanate from a single publication. The issue of consent was also relevant in this case. And Andrew Eddinghausen, it's worth noting, had not consented to the photograph being taken or being used in that way. So let's then turn to the next element, the element of publication. An action for defamation can only proceed once there has been a publication. This means that the defamatory material must be published to at least one other person beside the plaintiff. So it's not defamatory for me just to say something negative to another person. It will only become defamatory when there are other people present. Of course, in the journalism or media context, this will rarely, if ever, be a problem in an action against a media defendant or a journalist. It's also worth noting that each republication constitutes a separate cause of action. So it's not just the first time that something is published that can give rise to the defamatory imputation that leads to court proceedings. Every subsequent publication can constitute a separate cause of action. And mere use of the word allege does not excuse a republication in this context. So simply republishing something that is defamatory by using the words alleged or allegedly is not going to protect you from defamation law. One of the complexities of defamation law is that the plaintiff can sue wherever the defamatory meaning has been published. So this means that you can potentially sue in more than one jurisdiction. But what happens then, of course, where material is published on the internet, and as such it is therefore potentially available anywhere? Well, there have been a few cases that have touched upon this, but the leading case is actually a case from the Australian High Court known as Dow Jones and Gutnick. Now, in Dow Jones and Gutnick, the High Court had to decide whether a Melbourne businessman, Joseph Gutnick, could bring a defamation action in the Victorian Supreme Court over an article published in the online edition of the weekly financial magazine Barron's, which was based in New Jersey. Now, it was proven that 5 copies of the print edition of the magazine were circulated in Victoria, but the key issue was whether Gutnick could sue over the internet version, which had over 500,000 subscribers internationally, of whom about 1,700 had Australian-based credit cards. Now, this was one of the first times that any of the world's high courts had considered this tricky issue of jurisdiction for internet publications. Now, ultimately, the court decided here that publication occurred not where the material was uploaded, but where a third party downloaded and read it. So publication over the internet for the purposes of defamation only takes place when material is downloaded, read, and understood by a person. And so here, the fact that the people were potentially reading it in Australia meant that Gutnick was able to sue Dow Jones, the publisher of Barron's, in Australia, even though Barron's magazine was based in New Jersey in the United States. And that's a very important decision for all media organisations and journalists to remember. The third and final element is that it must be reasonably referable to the plaintiff. To work this out, the test is whether a reasonable person having knowledge of the relevant circumstances would understand the material as referring to the plaintiff. Now, in order for there to be sufficient identification of the plaintiff, some general principles to note are that, first of all, it doesn't have to be by name. It can still be referable to the plaintiff even if the individual is not named. It may come from knowledge of extrinsic facts, and it may be named in another publication if subsequent publication by defendant, if there was an earlier publication by a third party, or if subsequent publication by the third party if defendant invited the reader to ascertain the plaintiff's identity from that source. The issue of identification does not mean what the writer intends in the material, but instead how it is likely to be comprehended. And that brings us to an end of this first podcast on defamation law. As I've said, in this podcast, we've simply gone through the three elements of defamation law. In the next podcast, we will focus on the defences to defamation law, which really goes to the heart of that balancing act, which is so tricky when we are talking about defamation. See you next week.